Thank you very much, Andrew and Bart. Be sure to tune into Channel 13 News tonight at 10 o'clock for the rest of that story. Coming up on the show today, Catherine Hammond of Hammond Law Group. We're talking about why how you own your home is so very important in the grand estate planning scheme of things. Catherine, you are a frequent flyer. It's such a privilege to have you here. Welcome back to the Extra.
Thank you so much. So good to be here.
It
Happy
is
snowy
good.
morning.
Oh my gosh, yes. And you had a little adventure of your own coming in today.
I did.
Wow. Okay, so let's kick it off, because one of the first things that you want to talk about is why how you own your home is really important.
Yes, and that it's something when most people buy a piece of property, they just buy it with whatever names on it the real estate agent and or title company tells them to put on it. There's a default pattern without really thinking through all of the implications. And folks in the real estate industry don't get to see all of the implications like we estate planning attorneys do. And so one of the things that we become very passionate about is educating folks in the real estate industry about why the way you own your home is relevant to the rest of your life. So I'll try to keep it very basic here. There are 3 different ways that people can own their property. One is as a sole owner. That means that you are the only owner on the property. It's just your name. One is tenants in common. So you and somebody else have your names on the property. And then there is a joint tenancy with right of survivorship. That third one is the one that most people who are buying a property with another person think that they are getting, but it's not always what they actually have on their deed. So it becomes very, very important. Let's walk through each one of those maybe and talk about how things work and what might be good about that and what might be the drawbacks, because there's no one best way to do this. It all depends on what your situation is and how you want things to go.
How about if we do this? Let's take a quick pause and let's get the commercial break out of the way so we can come back and walk through each of those pieces.
Wonderful.
And I'm really looking forward to hearing that. The time is 9:15. Yes, I can see it from here. I'm lucky. Let's take a quick commercial break. We'll be right back with our guest, Catherine Hammond of Hammond Law Group. This is The Extra on KRDO News Radio. And the time is 9:19. Welcome back to The Extra here on KRDO News Radio. I'm Ted Robertson, hosting for the wonderful Renee Roberts today. Joining us in studio, in the Extra studio, is Catherine Hammond of Hammond Law Group. Catherine, we're going to walk through lots of different definitions here right now about how you should own your home.
Yes. So as we touched on earlier, there are 3 ways that you can own it. Well, actually 4. One would be sole ownership. One would be tenants in common. One would be joint tenants with right of survivorship. And then one would be to own it in the name of a trust or another type of entity, an LLC, something like that. So sole ownership is just you on the deed. It's great. You're in sole control. However, if you become incapacitated, there might be some challenges if somebody needs to sell or refinance your property. Then we're stuck relying on a power of attorney, and title companies and mortgage companies are very picky about powers of attorney. Often they want your power of attorney to be brand spanking new, less than a year old, or on their form. So that's one potential area where sole ownership may not be perfect. And then when you pass away, the property is going to have to go through probate to pass to whomever else is going to receive it, either whoever you have by state law, if you don't have a will in place, or if you have a will, whoever you've named in your will.
So in that scenario, should there not be something like a living trust or and then a durable medical power of attorney if you know that the medical issues are coming up and you have control, more control over this along with a power of attorney, yes?
A living trust would solve that problem at incapacity. Mm-hmm. It means that whoever your successor trustee is has full authority to do whatever needs to be done. And then when you pass away, It doesn't have to go through probate. Again, your successor trustee can step in and take care of things.
And of course, we need to see you, because a living trust isn't something that you can do online or out of a book, or it can be very complex.
Exactly. I've seen that they have do-it-yourself brain surgery books. And they have do-it-yourself legal documents as well. I don't recommend either one.
Everybody's situation is different, and there's lots of nuance involved.
Right.
Okay, so when you get to tenants in common, does that add another layer of complication to this, or complexity?
It's just different. So tenants in common is two people owning a piece of property. Both of your names are on it. Now, one of the things that people don't really know about in Colorado is that if your deed just has you and somebody else's names on it, without anything more, it is in tenants in common. A lot of people assume that if there are two names, they own it in joint tenancy. Very different form of title. It has to specifically say joint tenancy or joint tenancy with right of survivorship in order to be in joint tenancy. Otherwise, two or more names, it's tenants in common. And it's the same kinds of issues. If one of you or both of you become incapacitated, we have to try to get the power of attorney to work. If not, then we end up doing conservatorship and guardianship. And then when you pass away, if one of the owners passes away and it did not say joint tenants, then the portion of the property that owns to the now deceased person has to go through probate in order to go anywhere, even if it's just to the other surviving owner.
So good legal documents make good tenants in common, yes?
Absolutely.
Like good fences make good neighbors.
Right.
There are times when relationships like that can fall apart, too.
Absolutely.
And then splits like that cause a lot of problems. So, again, we've got to come and visit with you. We have to be prepared. Basically, here's what I've learned in business, for example. When you form a partnership with somebody in business, you really form that starting with the divorce papers.
Right.
And then you move backwards into what the partnership agreement's going to look like. That's what I've learned. And I'm thinking it's probably something similar if people are smart enough to recognize that tenants in common is not what they think it is, or they need a clearer definition. They still need you.
Absolutely. You absolutely want to have a plan for in the event of some sort of ending of the relationship. And we know it's going to end in some way because eventually both people are going to pass away.
Right.
So make sure that you have a plan for how things are going to go then, unless you simply don't care about what happens with your property and whether it goes to the other owner or to your other loved ones. If you don't care, not such a big deal. But most people, once they invest in a property, care a little bit about what happens to it and making sure that it's going to the right person. But important to know that if your deed does not specifically say joint tenancy or joint tenancy with right of survivorship, it's going through probate when you die.
Okay, and as you indicated earlier, I don't mean to be crass, but I will be direct. You're not always going to get this kind of help or assistance from your real estate agent or from your title company. Is that right?
Exactly, because their job is not to give you legal guidance on how you should own your property. Their job is to get you the property, and they would be taking on a lot of probably inappropriate liability if they tried to tell you how you should own it. So you want to work with them for taking ownership. You want to work with an attorney to what form of ownership is going to meet your needs for the long run.
Okay, so sole ownership, fairly easy, fairly cut and dry. Tenants in common can be very complex, and you should not go into that without some kind of arrangement. Then now we come to joint tenants with right of survivorship.
Yes. So with joint tenancy, still the same issue if either person becomes incapacitated at some point, has a stroke or dementia or a brain injury, gets into an accident. We're still going to have issues, excuse me, and maybe have to go through living probate if somebody is incapacitated just in order to sell or refinance the property. The joint owner does not have the right to sell it without both signatures, of course. So then when you die, the thing that's nice about joint tenancy is if you want it to go to the other surviving owner, let's say it's your spouse, with joint tenancy, it just passes automatically to the other person. You don't have to worry about probate. until the second person dies. At that time is when it would have to go through probate with joint tenancy. Now, in some situations, that's what you want. In some situations, and I'll say one of those is with blended families, you may not want it to just automatically go to your spouse. I run into, and we might have a chance to touch on this later, I run into a lot of blended families who put everything in joint tenancy with their spouse and then accidentally disinherit their kids when they die.
Oh, goodness. Well, Catherine, it's just about 9:27. Let's come back to that. It's time for a short break and then a news update and weather with Mike Lewis. This is The Extra on KRDO News Radio. The time is 9:36, and welcome back to The Extra here on KRDO News Radio. Ted Robertson hosting for Renee Roberts today. Be careful out there. It's still snowy, sloppy, and kind of goofy. So stay warm, dry, and safe. And rejoining us in the Extra studio this morning is Catherine Hammond. And Catherine, I have literally a $10,000 to $20,000 question for you.
Okay.
All right. So as we talk about the whys of how you should be involved with home ownership, we need also to talk about planning in advance. No matter what the scenario is of your home ownership, whether you have people involved, blended families, anything like that, you should spend the roughly $4,500 to $6,000 it will take for Catherine, for you, to set all that up so that everything can transition properly in the event of death or incapacitation. But Catherine, you shared with me when I asked you this question initially how much it will cost you after the fact if you show up at Catherine's office or anybody's office. It's very expensive.
Right. A lot of people want to save their money and are not willing to invest it in getting a good plan in place. But the thing that I try to remind people is planning does save you money in the long run. Are you concerned about the cost short term or long term? So the kinds of things that I see when people don't invest in a good plan, and a good plan can cost you, depending on your situation and what you need or don't need, anywhere from $1,000 or $2,000 to $6,000 or $7,000. At most law firms, that's definitely the ranges that we're in. When you pass away, well, first, let's say if you become incapacitated and you don't have the right documents in place and your family has to go through living probate, it's going to cost you probably $5,000 to $10,000 to set that up, depending. And then there are going to be ongoing fees on an annual basis after that, in addition to it being really intrusive. When you die, if you have a probatable estate, which most people with real estate do, then once you die, it's going to be a good chunk of money. They say the average cost of probate in Colorado is between 3% and 4% of the gross value of your estate. That's on a $1 million estate, that's $30,000 to $40,000. Most of the probates that we see are not that expensive, but most of them end up being at least $10,000 to $20,000 all in between the attorney's fees and the court fees and the personal representative and publication and bond, and all of those things add up pretty quickly. And I've had a lot of people over the years who have said when their parents died, the lawyer got most or all of the estate.
That's very hard to hear. It brings up some memories of my own, and I've shared a little bit of that with you. I have lived this, I've experienced it, and there was some planning. It wasn't done properly. So when we did bring our attorneys in to fix the problems that you've described here today, which I have had, we were roughly $16,000 when we could have spent somewhere between 2 and 4 properly planning. There's a huge lesson there, don't you think?
Absolutely. It's been a great system for us lawyers, but for the individuals and families, I would much prefer that you get to hang on to your money, and that requires setting up a good plan in the first place.
Well, and there's another toll that all of that stuff takes, and I'm sure you've seen that, and it's even harder. It's mental, which becomes physical. It's time-consuming, and if you lose your health from all of this stress and fretting and worry, how much is that going to add to that $10,000 to $20,000?
Right.
So, Catherine, you are a lover of teaching. You have great workshops going. So let's talk about a couple of your workshops coming up where you can talk in depth and detail with the attendees about what we're discussing today.
Right. Yeah, we have a funeral planning workshop next Tuesday, May 23rd. That one is, it's a workshop designed for our clients, but we're opening it up to the public, talking about the things that you want to make sure you have planned out and communicated before you pass away, and how to make sure that there is money available for your funeral when you die. A lot of people think that somebody will be able to get your bank account or life insurance money to pay for your funeral. It takes weeks typically to get those, and the funeral home can't wait weeks to be paid. They're not going to wait weeks to be paid. They want to be paid today for good reason. So on May 23rd, we're going to be having that workshop at 2 o'clock in the afternoon. People are welcome. Just go to our website, coloradoestateplan.com, or call our office at 719-520-1474. And then our next estate planning workshops are on June 6th in the afternoon and the evening. That's a Tuesday, and then Saturday, June 10th.
Go, be taught, learn well, and
save money and heartache.
You save money and heartache. I'm here to personally testify that spend a couple of thousand now and spare yourself all the heartache. I've been through it. And Catherine, you've seen the toll that it takes on people emotionally and physically when they show up at your door. I waited too long. This happened before we got the planning done, or I didn't know I had to do this. That's got to be really hard.
It's very hard, and for me it might be particularly hard because that's how I got started in the business. When I was 22 and my mom was incapacitated and needed to move to a nursing home, and she didn't have the right documents in place. And so I had to go through that living probate process, and it was really, really emotionally overwhelming.
And in those messages that run here at KRDO, you describe that as a mess of legal trouble that you had to untangle. So you are an extraordinary person for having dedicated your life now to making sure other people don't have these problems. So I urge you, again, based on Catherine's experience, based on my own, based on our not wanting you to live the things that we had to live through, May 23rd, at Catherine Hammond Law Group offices in the Education Center. No charge, 2 p.m. That's on a Thursday. Is that right?
It's a Tuesday.
I'm sorry, on a Tuesday. Thank you. And that's the funeral planning workshop.
Yes.
And then the next set of workshops is the estate planning workshops, general estate planning workshops. Those are on June 6th and June 10th. And website and phone number one more time, please, Catherine.
That is coloradoestateplan.com. And then our office phone number is 719-520-1474.
Okay, and next on our agenda, and let's tease this one for the next couple minutes before we go to the break and come back and get into the detail, the beneficiary deed. Fun stuff. Okay, so what does that do?
Yeah, awesome. Are we ready now?
Yeah, let's we got about a minute where
Perfect.
We can sort of frame the discussion for the next segment.
Beneficiary deed, a lot of people think that is going to save them from having to go through probate, gives it directly to their kids, but there are things that people don't understand about a beneficiary deed. Creates similar problems if you become incapacitated, but then the other big thing is you can't qualify for Medicaid with the beneficiary deed in place. There's a big, fat, bold warning on the front of the Colorado beneficiary deed that says, with this in place, you don't get Medicaid. A lot of people who are trying to save money and do a cheaper plan are the ones who need to be concerned about Medicaid planning and making sure that they can qualify. With this deed in place, you can't qualify.
Wow, you're bringing up more questions. It's 9:44, Catherine. It's a real privilege to have you here. I'm enjoying the time with you today. Thank you for being here. It's 9:44. Let's take a quick commercial break. We'll be right back with more from Catherine Hammond. This is The Extra on KRDO News Radio. Time is 9:49. Let's and welcome back to The Extra here on KRDO News Radio. I think I'm Ted Robertson. I know I'm hosting for Renee Roberts today. I'm so sorry she's under the weather. Rejoining us in the Extra studio is Catherine Hammond, having a an interesting conversation, bringing up some memories for me, certainly for her. I think we both share some similar experiences, and we don't want you to have anything like that kind of experience that we've lived. It's why you're here. It's why you teach. It's why you love to do what you do, and you do an awful lot of it, and you do it well. So we are talking about beneficiary deeds and basically what those do, what it doesn't do, how it helps, how it allows you to do certain things, protects your property, that kind of thing. Let's run through that.
Right. So a beneficiary deed, again, is something that a lot of people put in place as a cheaper version of a way to avoid probate if they don't want to have to pay for a revocable living trust. But again, it has some drawbacks. So if you become incapacitated, nobody has authority to transfer the property. And so we might be looking at a living probate. And then it has a big warning right on the front of it that says you will not qualify for Medicaid with this deed in place. And so if you become incapacitated and need some sort of care and need Medicaid assistance, somebody is going to have to undo the beneficiary deed. And we may not have somebody who has the authority to do that if you don't have the right estate plan in place. So, and then when you pass away, it gives the property directly to your loved ones, which might be the way that you want things to go. But a lot of people don't want their son-in-law to get his hands on the property, or they have a daughter who's a little financially irresponsible right now, and they would prefer for her to get the money staggered out over time. A beneficiary deed can't accomplish those things.
Okay. So you're putting me back on track here because there are several talking points you want to go through. Which one do you want to address next?
I think maybe the only other important thing related to property ownership is just the special considerations for blended families. With blended families, as we touched on earlier, if two people get married and they both bring children in from a previous relationship and put everything into joint tenancy, and then one of them dies, that person's children get disinherited. Most people don't want that in a blended family. Most people want to balance the interests of taking care of new spouse, but also leaving something for their own children. Even if it's a great relationship between my kids and my new spouse, when I die, I want to make sure that they get something, because a lot can happen and my well-intended spouse may not be able to take care of my kids in the way that they had intended. So joint tenancy can mess that up. So very important to sit down with an estate planning attorney and walk through, who do you want to be able to live in the house if one of you passes away? How do we want to make sure that some money or assets go to each spouse's children? Important to know that that surviving spouse typically has a right of election against some of the property after one spouse dies, and that can affect how much goes to spouse and how much goes to children. So if you're in a blended family, bottom line, sit down with an attorney and talk through all of the different things that you want to accomplish.
I guess there's an element of this that unfortunately you have to encourage people to plan for the worst. And sometimes that doesn't cast a favorable light on being able to trust somebody or things that are humanly natural, like emotions and greed and other things that can take over when all of a sudden there's money on the table and somebody's not healthy.
Absolutely. And one of the most common situations that I see, Ted, is a well-intended surviving spouse or a well-intended child then gets affected by their new spouse. So let's say surviving spouse has the best of intentions. 5 years later, they get remarried. That new spouse can change all of those great intentions.
Yes.
Or I leave all of my money to my son, and his wife can change all of his great intentions. So it's the in-law factor. Typically, that's the thing that encourages estate litigation. It's typically not our actual family. It's promoted by the in-laws.
So never a suggestion that you shouldn't trust your family or your loved ones, but you should plan for the eventuality that relationships can change. They can become bad. And that, of course, is when things really can get ugly in any of these scenarios. Yes?
Right.
Wow.
And
okay.
even without a relationship turning bad, things happen.
Yes.
So.
Catherine, unfortunately, we're running out of time. And I know we're going to have you back in about a month, right?
Yes.
And you're going to have more workshops. So very quickly, it's May 23rd at Catherine Hammond Law Group's offices in the Education Center. No charge, Tuesday at 2 p.m., a funeral planning workshop. And then June 6th and 10th, general estate planning workshops also at the Education Center for Catherine Hammond Law Group. Catherine, thank you so much. It's just about 9:55, and that's it for today's edition of The Extra. Renee Roberts back tomorrow morning at a touch after 9. In the meantime, stay tuned to KRDO News Radio. Tom Martino, a.k.a. The Troubleshooter, is up next. Tom's got the answers to your problems with bad businesses, and we'll also tell you who the good guys are. And it's all right here on KRDO News Radio.